Prosecutors are claiming confrontation was streamed on FaceTime. TA against the state of Florida right now. What's happening, everybody? It is Sunday night, man. It is hotter than Hades outside. Hope y'all staying cool today. I got my cool hat on. We staying cool underneath the sun, even though I really haven't been in the sun all day. Hope y'all doing well, man. So wild ass turn in this case. I signed up for the updates at the processor with the state, and was able to get my hands on the pretrial motion. And in it, I have to say, I think TA is going to be all right, unless. And look, I'm not an attorney. I mean, I've been through plenty of legal things throughout my life, so I understand a little bit. But and not in a bad way, but in a good way. The point that I'm trying to make here is they haven't proved anything yet. They're not going to, right? It's just a motion. It's just a motion for pretrial detention. And by the way, I did see on Twitter that people were making claims that there was already some information out there about TA's text messages and this, that, and the other thing. And look, ain't nobody got a goddamn thing. Okay. If TA's attorney doesn't even have the evidence, if he doesn't even have, any of the Brady material, what piece of crap on Twitter has it? None of them. So anybody making claim that they know something, they're just full of shit. And I don't even know why somebody would make that claim. People are so wild with their accusations, and they're just wild with how they do life, man. And some idiots out there just slurp that stuff up. Not here. Truth, honesty, and transparency coming right at you about Terrion Arnold versus the state of Florida in what will be a very polarizing and a very public trial if it goes that far. Now, in his defense, he did hire this guy right here. Oh, there he is. Harvey A. Steinberg, founding partner and top Denver criminal defense attorney. This is the guy that, what was here's it is. The man that Colorado sports figures call when they're in trouble. That's his moniker. Mr. Steinberg explains his passion for criminal defense. He says, I became a lawyer because I could talk my way out of anything. It is important that somebody stands up to the system. Otherwise, the system will roll over everybody. The system demands that we hold it in check. I do it for the satisfaction that comes with making sure my clients get the best results possible. Now, he's having a little bit of trouble in the Kellen Winslow case, as he should, because Kellen Winslow is an absolute monster. But in this case, I think TA's got the right peoples here, man. This guy was rated best lawyers in 26, 24, 22. I mean, look at these news releases of all of his cases. I mean, this guy knows a little bit of something, huh? Look at all these notable court cases, man. People versus, right? U.S. versus, those are big cases. Man, good stuff here. So he's got a really good attorney. He's got that going for him. If you're not in favor of TA, you're on the wrong damn channel, right? And let me clarify something else real quick before I go any further. To the people, the fans, listen. We are supposed to be the one pride nation, right? We're supposed to be Lions fans. Now, that doesn't mean that we blindly follow. That doesn't mean we blindly accept, right? But it does mean that we should have our wits about us. It does mean that we should use common sense. And it does mean that we should believe in the same set of laws that you would want going for you if you were in a sticky situation, which is innocent until proven guilty. I have never been more disgusted in my life with the one pride fan base, and for those of you that are guilty of it, trashing TA because you don't like the way he plays, right? Trashing TA because you don't think he's a good player. Trashing TA because you wanted an edge rusher instead of a cornerback. And so you trash the guy because he's going through this situation. How many times have we seen people get blamed for something and then they were innocent? Hello. Just happened to me a couple of months ago. So it's never right or fair to judge somebody until the facts are presented. Now, if the facts are presented and those facts put Terrion Arnold's head on a spike, it is what it is, right? At that point, it doesn't even matter anymore because he won't be part of the One Pride. And the Lions don't need to do anything right now to change any of that. They need to take care of business. They need to let this process play out, right? Now, if that process means that he's going to retain in jail until the trial, well, they might be able to act on that, and they might just act on that. But we'll see if that happens, okay? Now, this pretrial motion that I got my hands on, I thought it was interesting what the state wrote. At the very least, I don't think they have a freaking case until they have some sort of an electronic evidence on him that is like overwhelmingly convincing that he's done something. And I'll explain why here in just a second. So tonight we're going to get into the pretrial motion. That's probably a 10-minute read. And then I want to go through this little short piece here that I prepared. So good evening, Lions fans. Everybody, welcome into Rock Down Detroit Lions here. It's Sunday night. Terrion Arnold case is taking a major turn. The state of Florida's motion for pretrial detention provides the clearest account yet of what I believe prosecutors allege has happened and who is cooperating and what the evidence may or may not connect to Terrion Arnold in this case. Now, Arnold faces 8 felony charges, which were recently changed, I believe. 3 counts of kidnapping, 3 counts of armed robbery, and then the kicker, 2 counts of conspiracy. Now, I believe if those charges were changed from the original 8 that were reported, I think the conspiracy was thrown in simply because they don't have to prove he was actually there. And so if they really want to hang this man out to dry on anything, and if anything is going to stick, if I was a betting man on this case, I'm going to tell you, if TA ends up guilty, 6 charges are going to go away. At least 1 conspiracy charge will stick, and he'll probably get 4 or 5 years, maybe 8 at the most, right? It could carry a life sentence, but I think in the minimum, it's somewhere in that 10 to 15 year range. So kidnapping, like I said, robbery, and now conspiracy make up all 8 charges. Everything discussed today, let me put the disclaimer out there, remains in an allegation, okay? Arnold has pled not guilty. He has not been convicted of anything, and he remains presumed innocent until the court of law says otherwise. Now, we are going to review the entire motion, but first, here are the biggest developments and unanswered questions that were on my mind today. What the state wants. Number 1, prosecutors are asking the judge to keep Arnold detained without bond while the case moves forward. Number 2, the state argues that the seriousness of the allegations and the alleged use of firearms in this case make him a danger to the community. Those 2 things could keep him in jail. What has happened? What was the motive for Terrion Arnold to commit this crime, if he did? Approximately $251,000 in property was stolen from his Airbnb that was rented by Terrion Arnold, and several of the co-conspirators had been frequenting this property for the last couple of months. Arnold was responsible for what was approximately $245,000 in the personal losses. Prosecutors claim that Arnold suspected 2 men who investigators say were not responsible for this theft, and 2 of those men were the 2 men that are involved in this case. Then there's the alleged plan. What had happened in this case? Why is TA sitting here, in this situation, anyway? And that's because the state says the men were lured to an apartment under the belief that one of the men was going to be meeting a woman for, get it, sexual relations. Prosecutors allege armed men were hiding inside the apartment. Maybe TA is guilty of pimping instead of conspiracy to do all this other stuff. I'm just kidding. Bad joke. 3 alleged victims were reportedly held, beaten, threatened, questioned, and robbed for approximately 1 hour. Now, the biggest question is what connects or allegedly connects Terrion Arnold to the case. Prosecutors claimed that the confrontation was streamed through FaceTime while Arnold was traveling toward Tampa. Now, the motion describes a group chat in which Arnold and Bocahai Hilton allegedly gave instructions during the incident. The state says Arnold later arrived at the apartment complex but remained outside the apartment, allegedly. Arnold allegedly instructed Hilton, Freddie Hughes, and Jackson Ridgway to go upstairs. Prosecutors also claimed that Terrion Arnold drove Dalval, Christian Williams, and Ridgway away from the scene. Now, who's cooperating? Why is TA after 4 months? That's another thing that needs to be cleared up. Everyone's been saying he's been under investigation. Why did the Lions retain this guy if he's been under investigation this whole time? Pause right there. He wasn't under investigation that he knew of. He wasn't under investigation that his attorney knew of, because if he was, then he would have been brought in 4 months ago. Now, I think he was talked to at the very beginning, and then this all kind of went away. The case went on, people were charged, and then all of a sudden, a plea deal comes out of nowhere, and the people that are cooperating in this case, Ariana Dalval, Jasmine Randazzo, they have both admitted their fault in this case and gave sworn statements to investigators. Dalval claims that she was present when Arnold developed a plan and instructed her to contact Randazzo. Randazzo also claims that Arnold gave directions during the FaceTime call. Both women reportedly identified Arnold from a photograph. Like, are we serious right now? I could ID TA from a photograph. I don't understand how that is even convincing evidence, right? Of course they know him. It's no secret that they know each other. Now, did any of the victims identify Arnold? See, this is a big one for me, and I said this the other day, and now I'm going to double down because this is huge. The motion does not say any victim identified Arnold as someone who entered the apartment, carried a weapon, or even physically assaulted anyone, which means when each one of these victims was led outside to get into their car to leave, they didn't see Terrion Arnold sitting in the car. They didn't see Terrion Arnold standing outside. They didn't see Terrion Arnold inside or in a hallway or anywhere else. So if he's not even there, well, that's why the conspiracy charge was later added. The victims reportedly identified only Hudson, Williams, Hughes, and Hilton. Well, that part doesn't make sense to me. What about the two females? The two that were there at the very beginning? The two, or at least one of them, that opened the damn door, right? So were they not identified? I think that this motion needs to be a little bit more clear. The allegations place Arnold at the complex, but nobody saw him there besides Randazzo and Dalval. The allegations placing Arnold at the complex come primarily, again, from Dalval and Randazzo. The digital evidence question, this is the biggest part of the entire case. This is where the case rests for the prosecution, and then it's the testimony for or against Terrion Arnold with Dalval and Randazzo. So here's my questions and kind of the what's happening. Where are the complete FaceTime records, right? Does the prosecution office have it? You bet your bottom dollar they do. The group chat messages and the phone extraction reports. You can guarantee they have that information. Now, here's the question. This happened in February. It's mid-June before Terrion Arnold walks himself in and turns himself in. He had 4 months to get that information. It doesn't take 4 months. It takes 14 to 21 days for the powers that be, right, to cooperate with a subpoena. And if Apple, Google, Maps, right, if anyone didn't comply, well, then that would be a problem. But you would think they would probably comply, wouldn't be an issue. So does Google Maps history, does that place him there? Did the cellular records or the phone location services place Arnold where the prosecutors claim he was? Or Randazzo or Dalval claimed that he was? What did the GPS or the navigation or the location services say from the vehicle that Terrion Arnold allegedly drove? What does that show, right? Multiple phones, vehicles, devices, all allegedly involved, and those records could support the prosecution or it could contradict the cooperating witnesses and help clear Terrion Arnold. Let me make one more point on this. You all know, if you go in your phone right now, okay, and you pull up, if you got a Samsung, right, or, if you're an Android, and you pull up your maps, right, you probably can't see that. You pull up your maps, and you go to your location history, and it's going to show you your timeline. It's going to show you every single place you've been, and it has a log, right, that continues to go. Today, it told me I went to Meijer, and it told me I went to Town and Country Supermarket, right? Your phone will say the same thing. And there's also a little map in there with all these little squiggly lines of everywhere that you've been. So Apple does the same thing. So you bet that they have this information if it exists. If they were stupid enough to text each other, I doubt they were stupid enough or smart enough to turn off their map location, right? So GPS is huge. Here's another one. Y'all know when you drive up and down the highway, they have these things that scan your VIN number, right? Doesn't matter where you are, but in any major metropolitan city, and especially the state of Florida, because they have the most cameras out of anybody, you better believe that his car would have been located anywhere near that apartment complex using that VIN tracking system and license plate scanners and everything. I think they're called flock cameras. So anyway, there's enough here if they have that information that puts him at the actual place or location where this went down. Well, then he's guilty, right? They're going to hang him with a conspiracy charge. If they can't prove that, and if that information is inconclusive, they don't have anything but testimony from a convicted felon. So I just wanted to point that out because I think it's really damning information. And there's a lot of stuff out there that the TA could have been tracked by, whether intentionally or unintentionally, that could clear him from this case. My bottom line before we open up this pretrial motion, the state's case appears to focus on the claim that Terrion Arnold helped to plan, direct, and facilitate the alleged crimes, rather than personally entering the apartment or committing the physical assaults. The biggest questions are whether the cooperating witnesses can be trusted and whether the independent phone, vehicle, and location evidence confirms their accounts. Now I want to go through the complete motion and examine exactly what prosecutors are alleging. I will leave a link below in the description after this is produced later. Tell me what you guys think in the comments and in the chat right now. Do you think that they're going to find enough information on Terrion Arnold throughout all the different various methods of location history? All right. Now that I'm done with that whole spiel, let's get into this. How many people we got in tonight? I don't know if we got enough people in. All right. So, Mr. Thomas, let me address your comment first. He says, police scoped that man's phone already. This dude was on FaceTime. He's done. All right, so that's not a fact. Okay, and I'm going to read you the pretrial motion. This is why facts are important. Okay, nothing in this pretrial motion, nothing from anywhere else that you've been able to read, unless it was an opinion or some idiot with a microphone claiming that they know a fact. That's not true. Okay, what they are claiming is that he was in the car when the FaceTime was alleged, right? And that Bokai Hilton's phone was FaceTime for sure. They didn't say anything about TA. Okay, so that doesn't mean. Okay, so I made this analogy the other day. If I were to go rob a bank tomorrow morning at 9 a.m. and Mr. Thomas, I decided to FaceTime you while I was committing that crime, would that make you complicit? Would that make you guilty by association? Would that mean you're going to get a robbery charge because I did? Think about that for a moment. Just because I call somebody or text somebody doesn't mean that individual had anything to do with whatever I was doing. And my biggest takeaway from this whole case, I think TA was set up the whole time. I think that they were the only people that could have known that this type of money and assets were in this Airbnb. The only people that knew, that could have known, were the 8 or 9 people that frequented that home in Largo. And those are the co-conspirators and the people that were arrested already. And the driver for Terrion Arnold and Terrion Arnold himself. Those are the only people. How would someone have known this stuff was in that apartment? And why that apartment or that home, why was that home the only one that was targeted? Was it the owners of the Airbnb? Did they do it? That's more plausible, right? They're the only ones that could have possibly gotten in. Was there any forced entry? See, we don't know anything, and I haven't even looked yet to see what the details are surrounding the robbery case and if that information is even available. You bet your bottom dollar I'm going to FOIA that stuff come tomorrow, and I'm going to see what I can't find out, because that's what I want to know. I want to know what happened with the robbery. Who did they find out was involved in that, right? All right, here we go. Here's the pretrial motion. And we should be live. We should be live tomorrow, hopefully during this case. I got the text messages set up. I'm just hoping we can get in on a live feed. All right, so Circuit Court. State of Florida versus Terrion, Bernard, Arnold. Motion for pretrial detention. Now comes the state of Florida by and through the undersigned attorney, pursuant to Florida statute 907.041 and Florida Rule of Criminal Procedure 3.132 to respectfully petition this honorable court to order pretrial detention. Now, this gets a little sticky, and I'm going to explain what I think about it here in just a moment, too. As grounds for pretrial detention, the state would show that pursuant to Florida statute 907.0415C, there is substantial probability that the defendant committed the offense, and based on the defendant's past and present patterns of behavior, the criteria set forth in 903.046 and other relevant facts, that no conditions or release or bail will reasonably protect the community from risk of physical harm because the following circumstances exist. Now, what I'm going to read next is what has been asserted as claims made by Delval, Randazzo, and what the prosecutor has found and created as now evidence against Terrion Arnold. Let me go back to this part. It says defendant's past and present patterns of behavior. My question is, that's pretty boilerplate for what this statute says. But when I read that, I'm thinking, does TA have a history? Does he have other criminal offenses? Was he charged or, prior that we just don't know about? Because if something like that does exist, then I would call into question why Brad Holmes decided to draft this guy. But for any other reason, I wouldn't. This was not a bad draft pick. But that makes me believe that something else has happened, or they're just using boilerplate language to try to make it look like TA has a past or a history that his behavior was not good, right? I wouldn't know anything of that because I haven't heard anything in 3 years since TA has been a part of Detroit. I haven't heard one bad thing. So here we go. The defendant poses a threat of harm to the community given that he is presently charged with a dangerous crime, as defined by Florida statute 907.041, the 3 counts of kidnapping, harm or terrorize, and 3 counts of robbery with a firearm. Furthermore, there is a substantial probability that the defendant committed those crimes. The factual circumstances of the crime indicate a disregard for the safety of the community, and there are no conditions of pretrial release sufficient to protect the community from the risk of physical harm to persons. In the alternative, should the court determine the defendant does not meet the requirements for pretrial detention based on Florida statute 907.041, then the state would ask that the defendant be held without bond pursuant to Article 1, Section 14 of the Constitution of the state of Florida, because the defendant is charged with a capital offense or an offense punishable by life, and the proof of guilt is evident, or the presumption is great. Let me read that again. The state believes that since he is charged with an offense punishable by life, and the proof of guilt is evident, or the presumption is great, they are not making a claim that they have a rock solid case here with a statement. Again, it's more like boilerplate information. They stated State versus Arthur and State versus Fox, 2 cases that you could look up on your own time and break them down to hear kind of read through what those mean. The Office of the Attorney certifies that the grounds and essential facts alleged in the motion for pretrial detention are based on testimony received under oath and are as follows. Why is that statement important? Let me say it again. The Office of the State Attorney certifies that the grounds and essential facts alleged in the motion for pretrial detention are based on testimony received under oath and are as follows. So what they're saying there is the reason why they've implicated TA and indicted him is 100% based on testimony received under oath by a couple of felons, right? A couple of felons trying to wiggle their way out of a long prison sentence. All right, so between January 30, 2026 and February 1st of 2026, Terrion Arnold and his co-defendants, Bokai Hilton, Freddie Hughes, Christian Williams, Lindell Hudson, Ariana Del Val, and Jasmine Randazzo, as well as their friend, Jackson Ridgway, were periodically staying at Airbnb in the city of Largo, Florida, rented by Arnold. Also present during that period of time were two of the victims in this case, Jan Lopez and Daniel Tenesaka, along with their other associates and friends of Terrion Arnold and his co-defendants. So right there is why I made the statement that nobody knew that that money was even there and that those assets were there, whatever was stolen, the bags and, watch, whatever, besides those people, right? Those 8-9 people. That's it. Who else would have known to go, raid that guy's house and steal his stuff and that all that money would be there? And all those things would be. Something's fishy. I'm telling you, TA was set up. On February 1st, 2026, an unknown suspect or suspects stole multiple pieces of personal property belonging to Arnold, Hilton, Hughes, and Ridgway from within the Largo Airbnb. Terrion Arnold suspected Lopez and Tenesaka were responsible for the thefts, which they were not. Now, they're saying that Terrion Arnold is the one that implicated Tenesaka and Lopez, but that is from testimony from Del Val or Randazzo. Believing that Lopez and Tenesaka were responsible for the theft, Arnold and his co-defendants conspired to lure Tenesaka to the apartment belonging to Del Val and Randazzo to threaten Tenesaka and Lopez and retrieve the stolen property. Arnold, Hilton, Hughes, and Ridgway later called the Largo Police Department and reported the theft of their property. Arnold's property loss was reported to be $245,000. Hughes' property loss was reported to be $4,700. Hilton's property loss was reported to be $1,300. On February 3rd, 2026, Arnold and Hilton coordinated and directed both Del Val and Randazzo to electronically contact Tenesaka. That just means text, call, email, whatever, to lure him to the apartment of Del Val and Randazzo, located at blah, 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 blah. I'm not going to read the address. To engage in, get this, sexual relations with Randazzo. So, like I've said, if he's guilty of anything, he's probably, guilty of pimping somebody out, right? Right? I mean, it's pretty rough that you're having someone go meet some chick to have sexual relations with. I mean, that just sounds all sorts of wild. Defendants Williams and Hudson arrived at the apartment in possession of firearms and met with Del Val. Williams and Hudson then hid inside the apartment to await the victim's arrival. Lopez and Tenesaka, along with their friend Soldier Anderson, drove to the apartment at approximately midnight on February 4th, 2026. Upon arrival, Tenesaka and Anderson went upstairs to the apartment, located on the third floor, and were greeted at the door by Del Val. Once inside, Tenesaka asked Del Val where Randazzo was. Del Val advised Randazzo was not home. Tenesaka began looking through the apartment for Randazzo, and that is when Tenesaka entered a bedroom with Anderson following behind. Tenesaka opened the closet door, and that is where Williams and Hudson were hiding. Williams was armed with a semi-automatic firearm, and Hudson was armed with an AR-15 style of a rifle. Hudson emerged from the closet, pointed the rifle at Tenesaka, grabbed him, and began striking him. Williams emerged from the closet, held Anderson at gunpoint, and began striking him. After several minutes, Lopez, this is what doesn't make any sense. After several minutes, Lopez, still within his vehicle, became concerned for his associates and went up to the apartment. Upon arriving at the apartment's front door, Lopez could hear a commotion and loud yelling from a male coming from within the apartment, and he entered. Lopez entered the bedroom and was then immediately pistol whipped by Williams. This is what doesn't make any sense to me. If these guys were lured to this apartment for sexual relations, right, with Randazzo, why would Lopez get concerned after a few minutes? Is this boy a two-pump chump? He's just, oh, it's been 7 minutes. They should be done by now. That doesn't make any sense to me. I feel like there's some impeachment that can happen here. That makes zero sense to me. You all of a sudden get concerned. Your boy's supposed to be upstairs doing, whatever he's supposed to be doing, and you get concerned after a few minutes? I don't know about that. Anyway, DelVal sat on the bed in the same bedroom and utilized her phone to stream the confrontation, which was viewed by Arnold. Now, that's alleged viewed by Arnold. They have no way of knowing that it was viewed by Arnold, Hilton, and Hughes as they were still en route from Tallahassee. Simultaneously, a chat group was created, which was joined by Hilton, who was seated directly next to Arnold within their vehicle. So let me make this very clear. They're trying to say that DelVal created the FaceTime, right? And that Arnold, Hilton, and Hughes viewed it because they were in the same car. They didn't say that Arnold opened up his phone and looked at it on his phone. They didn't say that. They didn't say Hilton opened it on his phone and looked at it on his phone. They just said it was viewed by Arnold. Well, how do they know that? Well, testimony. They're taking this chick's word that Arnold was on the FaceTime. That's what they're taking. But if they don't have any proof that he was actually on it, if they don't have any electronic evidence that shows that he actually opened his phone, that's a problem, right? However, it says in here that when the text group was created, that the only person that joined it was Hilton, not Arnold, and not the other guy, just Hilton. So this chat group, again, was joined by DelVal, Hudson, Williams, and Randazzo. Remember, DelVal, Hudson, Williams, and Randazzo were in the apartment. Hilton is the only one that was in the car, allegedly, that opened up this chat group. Arnold and Hilton gave directions to DelVal, Williams, and Hudson as the assaults against Tenesaka and Anderson continued. Williams and Hudson continued to repeatedly batter and question the three victims about allegedly stolen property for about 1 hour. On February 4th, 2026, at approximately 0100 hours or 1 a.m., Arnold, Hilton, Hughes, and Ridgway arrived at the apartment complex and parked. Arnold instructed Hilton, Hughes, and Ridgway to go up to the apartment. Within the apartment, Hughes joined Williams and Hudson within the bedroom where the three victims were being held. Hudson, Williams, and Hughes continued to batter the victims with their fists and feet, threaten them with death. At one point, Williams placed a firearm in Lopez's mouth, putting all three victims in fear of their death while forcibly holding them within the bedroom against their will to facilitate the commission of a felony, to inflict bodily harm, and or to terrorize them. While inside that same bedroom, Hudson, Williams, and Hughes also stole the wallets, phones, jackets, cash, and jewelry belonging to the victims, which was committed to permanently deprive the victims of their respective property. At approximately 0100 or 0140 hours or 1:40 a.m., Tenesaka was escorted out of the apartment by Hughes, who was armed with a semi-automatic firearm. Lopez and Anderson were forced from the bedroom to the living room. Anderson observed Hilton standing within the living room wearing a pair of yellow pajama pants. Lopez was then escorted out of the apartment by Williams, who was still armed. Anderson was escorted out of the apartment armed by Hudson, who was also armed. All three victims were forced into their vehicle and they subsequently fled. Around this time, see, notice how it doesn't say anything about Arnold. Arnold was never seen. Arnold was never implicated by any of the victims. He was never seen at the crime anywhere. At this time, DelVal, Williams, and Ridgway entered the vehicle driven by Arnold and left the scene. Following the victim's report of the offense to the police, a court-authorized search warrant was served on DelVal in Randazzo's apartment, and DelVal was arrested. Post Miranda, she admitted to her involvement. Through investigation, Randazzo was later contacted, admitted her involvement post Miranda, and was also arrested. Tampa, let me state what that means. Post Miranda means they were read Miranda rights. Okay, that's all it means. So that anything that they say can and will be used against you the minute you read or before you read Miranda rights, shut the hell up. So it goes on to say the Tampa police detectives generated 3 separate photo pack lineups for Hudson, Williams, and Hughes. These photos pack lineups were presented separately to Lopez by a police officer unfamiliar with this investigation. Lopez positively identified each of the 3 defendants within their respective lineups. In layman's terms, that means they created a pack of photos. They gave it to an officer that was not involved, knew nothing of the case. They brought in the victims and they said, identify who was there. Okay. And then that victim identified who was there. Notice one thing. They only did a lineup for Hudson, Williams, and Hughes. What about Arnold? You mean to tell me that Arnold was never pointed out in a lineup, which means the dude was never there? Okay. Tampa police detectives also generated a photo pack lineup for containing Hilton. This was presented to Anderson by another police officer who was unfamiliar with the investigation. Anderson positively identified Hilton as the person standing in the living room with the yellow pajama pants when he was escorted out of the residence. Still, no Arnold implicated at all. On February 16th, 2026, Dalval gave sworn testimony, which was consistent with her previous post-Miranda statements to law enforcement. Well, remember, post-Miranda statements to law enforcement never mentioned Terrion Arnold. Additionally, her testimony confirmed, 1, she was with Arnold when he devised the original plan to lure Lopez and Tenesaka to the apartment. 2, that Arnold instructed her to contact Randazzo electronically so Randazzo could contact Tenesaka to lure him to their apartment. 3, that after the offense occurred in the apartment, she entered a vehicle being driven by Arnold to leave the scene. And 4, that Arnold advised he had to take her from the scene so that she would not get traumatized by the event. Okay, let me stop there. Terrion Arnold's car. If that car has location services on, and those location services point him at that apartment, he's cooked. It's that simple. But if it doesn't, and it's not accurate, or it's not found to be that's where he was, that's their case right there. Their case is saying that TA showed up and took her away from the scene. But it never once said that he was involved inside the apartment. That is why the conspiracy charge is so important. Right? That is why it's important to the state. And that is what his attorney is going to have to defeat, is the conspiracy portion, because he didn't do anything else. If you beat the conspiracy charge, I think, in my opinion, you're going to beat the rest of this case. If you can prove that TA wasn't there and that his car wasn't there and that his phone wasn't there, you're going to be able to beat this case. Those are the 3 main components to this case, in my unprofessional opinion, is that the car can't be there, his phone can't be there, and that's it. I think he's good, right? Now on March 20th, 2026, Randazzo gave sworn testimony, which was consistent with her previous post-Miranda statements to law enforcement. Additionally, her testimony confirmed, 1, Arnold was within the vehicle with Hilton during the FaceTime call when Arnold gave her directions over the call as to what to say to Tenesaka to cause him to be lured to her apartment. And 2, just after the offense in the apartment, with the FaceTime call still ongoing, she could hear Dalval enter the vehicle with Arnold, who stated to Dalval that it was not safe for her to be there and that she would be leaving with him. So here's the rest of it. Remember, it was Hilton that apparently was FaceTimed, right, and created that text chat chain with, not TA. It was never mentioned that TA, outside of Dalval and Randazzo saying that that's what happened. That's where the evidence has to be. If the evidence of the text messages show that it was sent to TA, you're not guilty. But if it shows he responded, then that's a problem. But you can't prove somebody was on a FaceTime call unless their phone was open to it. Just because if he was looking at Hilton's phone, how are you going to prove that? Unless you have unless you swiped or, you did a face, or unless you did a screenshot and you're able to screenshot it. That's the only way that you could prove that Arnold was ever on the FaceTime. But again, in this case, her testimony, all Arnold has to prove is that FaceTime call was never answered by his phone. That's all it has to prove. And then it has to prove that his car wasn't there. But it's kind of funny, right? That they're saying that they heard she heard Delval get into his car. Well, then that would mean, if that testimony was accurate, then that would mean that Terrion Arnold's phone was on and the FaceTime call was answered. And those things can be found out through subpoena. I forget the other term that they use, but through subpoena, they can send it to the phone company. They can send it to Apple, and they could probably see who answered the FaceTime call, when, how long they were on there, yada, 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 right? And the times. And then it should be able to triangulate where they were and ping where that phone was at that time. So wherefore the state says, based on the foregoing, the state respectfully prays. You don't see that often in a motion. For this honorable court to order pretrial detention on the defendant, I hereby certify that a true and correct copy of the foregoing motion for pretrial detention has been furnished to R. Timothy Jansen, attorney for the defendant, via email at jansenanddavis.com on this 25th day of June 2026. And then, of course, after this, or if not before this, Arnold hired this guy, Steinberg, to handle the rest of it. So that's not a whole lot of time for an attorney to have to prepare for a case. And again, we don't know when he hired Steinberg, if it was Thursday, if it was Friday, Saturday, we don't know. No idea. Because that pretrial motion was dated, where's the date? June 25th, 2026 at 12:32 p.m. It was e-filed on June 25th, 2026, which would be Thursday afternoon. And Terrion Arnold appeared in court Thursday afternoon, I believe, right? Wasn't that Thursday afternoon? Thursday morning? So there you go. That's the latest turn in events. The latest wild turn in events, if you want to call it that. That we now have testimony. We now have what they're considering to be evidence, and what evidence they're going to be supplying to the court or the jury when this goes to trial, if it goes to trial. Now, I will say this. I was going through some of his stuff, and I got to tell you, like, this dude gets a lot of people off. I mean, he gets a lot of acquittals. He's done a hell of a job. Like, he doesn't lose. Now, again, he's having some trouble with Winslow, and that's because Winslow had his erect pecker out walking down the road following some woman. What happened to Winslow, man? Kellen Winslow, what is up with that dude? Like, he's nutso. Nutso. Anyway, let's not be so quick to hang this guy out to dry, man. Look, I think that this case is weak, but Florida is also one of the most corrupt states in the union. I mean, they're extremely corrupt, just like Michigan is. But I feel like all courts are corrupt. It's a giant mess, man. It's a giant mess, and I think that there's 3-4 moving pieces to this. Terrion Arnold's car, Terrion Arnold's phone. If those two things are not anywhere near this apartment, and if he didn't answer a FaceTime call, I think the prosecution's going to have a really hard time proving this. Now, on the other side of that, you would think, okay, but then why would these people do that, right? Why would they go and perform street justice? For what? For what reason? They just wanted to defend their boy. They wanted to go get after this guy and these guys, and maybe so. You never know what's going on in someone's mind. I mean, I'm not going to say it, but people act differently for different reasons. People do certain things for certain reasons. And I don't know who any of these people are. I don't know their background. It doesn't appear like they're good people. I don't know if any of them have, lengthy criminal histories or anything like that. My biggest question is why the hell TA was even hanging around these people in the first place. There's got to be some better people to hang around, like athletes, like some other athletes. I don't get it. I don't get it. Yeah, there you go. I mean, so like EESIII, what a name that is. It says because $250,000, man, in stuff, they wanted to steal it. And that's what I've been saying. I think he was set up. I think that they probably wanted to go do this on their own. And if they could find it, more power to them. They were probably going to take it and shut the hell up. Now, I didn't hear anything about TA's insurance policy. I seen a couple of things flying around, but I didn't look into it yet. I don't know. So the Airbnb host liability insurance coverage covers hosts for up to $1 million in claims if a guest is injured or if their property is damaged. Airbnb Air Cover provides guests with a reimbursement process if hosts cancel or issues or another issue occurs. However, recovering high-value cash and personal items is difficult, which is why experts recommend additional coverage. Travel or personal articles insurance policies provided by carriers like State Farm. I don't know if he had any sort of an insurance policy or what it was outside of Airbnb liability coverage. I really don't know, but I haven't done any real research. If he had insurance, if he had insurance that was going to cover this, then that further. That further, makes me wonder what the hell was really going on. Like if the stuff was going to be reimbursed, then why would these individuals do this? Just get your shit back, right? And if you lose 10, 15%, so be it. But this stuff, the stupid tax, is way more expensive than $250,000. I'm sorry, especially for a guy like TA. Who makes more than $250,000 a game, right? Pretty stupid. It's not like TA is hurting for money. Yeah, TA definitely needs some different friends, man. He needs definitely some new people around him. Here's what I'll just say, man. It's pretty crazy that just random people would know that this money and these assets existed in this place to begin with. I don't think that that's possible. Okay? I mean, just let's be realistic. If you walked by someone's house and say, I bet you that house has $250,000 of stuff in it. Let's go get it. No. Very rare. That kind. You would have to really know who's in there, who rented it, and what's possibly, going on in there. Bunch of money, high-end athletes on vacation. Guarantee they got, chains and jewelry and money and everything else just kind of flying around. So in that case, it makes me believe that maybe the Airbnb host could have something to do with it, possibly, allegedly, not trying to accuse anybody, but I'm just throwing it out there as a possibility. That individual could have something to do with it. And the only other people that could have something to do with this are the people that were in that damn house. And so if TA was taken advantage of And then these individuals did this on their own. And then they try to pinch TA to say, give us some money. Who's to say that they didn't pinch TA from the beginning? They're not wealthy individuals. Maybe they grew up, trying to get out of the hood or whatever. I don't know their background. Maybe they're not even from the hood. Maybe they just wanted some money. Maybe TA said no. I don't know. It doesn't add up. But tomorrow's going to be a big day. I don't think that motion, if I were a judge, that motion wouldn't move me to put a guy behind bars for any length of time, because two people decided to testify against the guy that are now convicted felons that admitted their wrongdoing in this case. It doesn't make sense. But like I said, the phone and the car, those are the things that are going to exonerate him, or it's going to put him behind bars for a very long time. I would hope not. EES triple I. I would hope it's not enough. So tomorrow is pretrial. That's what this motion is. So this motion for tomorrow, this is pretrial detention. So let me clarify that. They're not really showing evidence tomorrow. They're making an argument that TA needs to stay in jail while the trial is ongoing, that he's a threat to society, and that he needs to remain incarcerated. That's all tomorrow is. They're not showing any evidence. Now, with that, I do believe that the judge is, in fact, allowed to see the testimony from the two witnesses prior to a trial. So that judge may be able to see this testimony, read through the transcripts, or watch the video, whatever it is, and then make a determination based on the two arguments that will be placed tomorrow. So outside of that, appreciate you, Joe. Thanks for the 10 joules, man. Outside of that, there shouldn't be any evidence tomorrow at all. That'll happen at a discovery hearing. They'll have a discovery hearing probably in 4, 5, 6 weeks, maybe less. I assume they're going to want a speedy trial. In this case, they're not going to want to drag it out. And the fact that he got one of the best attorneys on the planet means that their entire team is going to be ready to go. They probably have a dozen people working on this. And I can't imagine that they're going to want to wait. So the prosecutors had 4 months head start. And now the defense has to make up for that head start. So they need to be given everything, which is discovery. And once they get their discovery, then at that point they will create their defense, and they may even file a motion to quash. If they file a motion to quash, this and have a hearing on it, and they're going to state the reasons why. Look, Judge, you got my guy in jail for no reason. You got my guy charged for no reason. There's no evidence here. If they're given evidence that isn't strong enough, if they haven't been able to get exact triangulation data, right? GPS data of where TA was and where that phone and that car were, and if that phone even answered a damn call, what else do you got? You know what I'm saying? What else do you have? You don't have anything. I don't think you have a damn thing. Free TA. There you go. Free TA. And I get it, and I appreciate you, Major. Hold on, let me click on that thing. What is that? Mic drop. There you go. I love it. That's perfect for the podcast, right? Mic drop. Damn, 600 joules? What is that? I got to look these things up. I'm too lazy. I haven't looked these things up yet. Yeah, it's definitely going to cost them some millions in legal fees. It's not going to be cheap. It's not going to be cheap. If I was a judge, I would want one piece of hard evidence connecting that testimony. Me too. Me too. Look, I'm sorry. Two chicks, one cup, whatever you want to call it, man. They're taking a poop on TA. They're taking a poop on TA, and I think it's very simple. You know, they're faced with life in prison, and they're trying to wiggle out of it. They're trying to wiggle out of it. And once you present, facts to to the defense in this case, I feel like those facts are going to be weak. Who doesn't go chirp on somebody trying to get out of a case, right? Trying to get out of prison. It happens all the time. How many of those people have actually been convicted? You know what? Let's ask an AI that question. I want to ask AI that question real quick. Let me pull it up here. I'll just go right to the I'm curious. I am very curious. All right, here we go. Let's ask the question. How many cases are decided by testimony from a convicted felon tied to the case in an attempt to reduce their prison term? They then rat on another person not involved. How often does that person get charged and convicted? Hopefully that's enough to get it to work for me. That's not a very good prompt, but let's see. All right, how often does this happen? Let's see what it says here. Incentivized testimony, often referred to legally as jailhouse snitching, is exactly what's going on, or cooperating witness testimony in one of the most common factors in wrongful convictions. Damn straight. The percentage of wrongful convictions, according to data from the Innocence Project, incentivized testimony from a witness with criminal ties was a contributing factor in approximately 15 to 19% of all DNA exoneration cases in the United States. The National Registry of Exonerations, their broader data shows that in homicide cases specifically, nearly 50% of wrongful convictions involve some form of perjury or false accusation, frequently driven by jailhouse informants or co-defendants seeking leniency, reduced charges, or drop prison sentences. How often does this innocent person get charged? If a prosecutor chooses to use a felon's testimony to build a case against a target, that the likelihood of that target being formally charged is very high, estimated above 80% once an indictment is sought. Prosecutorial discretion. Prosecutors rarely accept a deal from a felon unless they intend to use that information to secure an indictment. The grand jury standard: to charge someone, a prosecutor only needs to show probable cause. And see, that's the case. Look, right now it's probable cause. They're just saying because he has ties to these people, they have relationships, they have history, that there's your probable cause. And the probable cause is the fact that he had $245,000 stolen of assets and money and everything else. So this prosecutor has probable cause, has used the witness cooperation statement, and because the grand jury proceedings are secret and the defense cannot present evidence, a felon's sworn testimony is often more than enough to secure a formal charge, even if it's entirely fabricated. Let that sink in. Even if it's entirely fabricated. How often does the charged person get convicted? Once an innocent person is charged based on a felon's incentivized testimony, the risk of conviction is alarmingly high. If the case goes to trial, legal experts estimate the conviction rate in these specific scenarios is between 60 and 75%, due to several structural factors in the legal system. High juror credibility. Despite their criminal records, cooperating felons are highly effective witnesses. Studies in legal psychology show that juries routinely believe jailhouse informants because the witness can provide intimate, highly specific details about a crime. Details they often secretly obtained from discovery documents, police leaks, or media reports. The Lafleur effect, the plea bargains. Up to 95% of criminal cases end in plea bargains, not trials. When an innocent person faces decades in prison based on a felon's testimony, they are often terrified into pleading guilty to a lesser charge just to avoid a massive sentence. Legally, a plea bargain counts as a conviction. Hidden incentives. Historically, prosecutors were not always required to disclose the exact deal given to the felons, such as drop charges or hidden cash payouts. Without this information, the defense cannot effectively show the jury that the witness is lying just to save themselves. That's alarming, right? 60 to 75% of people that are wrongly charged from witness cooperating testimony are convicted. I hate to say it, but we need ratification to the law. No more witness testimony. If you are charged in the same crime, you should not be allowed to rat somebody else out in that case. It shouldn't be allowed. I'm sorry. It just shouldn't. There ain't no way. If you are charged in the same crime and you are trying to rat on somebody that hasn't been charged in months and you're just trying to get yourself out of jail a little bit early or not at all, that person shouldn't be able. And I don't care what the crime is at all. I don't care what happened to good old police work, man. If you couldn't find anything on TA and then you had to go to a felon and say, hey, I'll shave 90% of your sentence. I just need to know if TA was involved. Just tell me he was involved. Sign here. I mean, how many people wouldn't take that deal? It's against everything that I believe in, but I wouldn't take the deal. There ain't no way. That's crazy. They hit you with the worst charge to scare you into coping a plea for probation. Yeah. Look, if TA gets convicted, he ain't getting probation. I'm almost willing to bet that. He ain't going to get just probation. I don't think he's going to get life in prison, and I don't think he's going to get 10 years. I think he'll get conspiracy pled down to something else. But I think that's a high bar that this prosecution is going to have to cross to be able to convict him. But anyway, I wanted to share with you all tonight the latest and greatest from the Terrion Arnold case. The motion for pretrial detention has been available since June 25th, 2026. Finally got my hands on it today. If you do go to the Hillsborough County site, actually, I'll post all that. I'll post all that in the description. But you can follow along with it. You can actually request to get text messages to follow along with it. Now, we'll all be following along tomorrow morning in going through, hopefully, what is a live stream of the Terrion Arnold pretrial detention hearing. And then after that, anytime there's any movement, we'll make sure that we're right here trying to cover it. So I'd like to know what you guys honestly feel. Let's throw up a poll. You guys have heard my story, what I believe in. You've heard my ideas about this, and my opinions about this case. I don't think the prosecution is that great of a case, but I haven't seen any evidence either. So who am I just to make a guess, right? I just don't think it's that great. Will Terrion Arnold, here's going to be our poll of the night, be convicted? Remember, all poll questions and answers are confidential. Nobody knows if you voted. So please vote. Man, I hope he's not going to jail, man. I mean, he's already in jail, but I'm hoping he's not staying there. I don't know that he still becomes a lion or still remains a lion, but at any rate, I hope he gets out of jail and that he's able to defend himself and this goes away. Pretty messed up, man. Pretty messed up. Yeah, I probably should have done that one, huh? I put yes or no, didn't I? Here, hold on. hold on. Let me kill this one real quick. Hold on. There's only 10 votes. Hold on. You're right, Trace. I should have had the unknown. You're right. There we go. Rats leave ships. What does that mean? I think I've heard that analogy before, but I don't know what it means. Prosecution makes deals with 90% of felons. Yeah. Well, it should be, let's see, EESIII. Man, you got to change that name. That's a tough one. Well, it should be, but they have to have some other evidence to go along with it. Mr. Thomas says not looking good for Arnold. EI says our system's broken. Yes, it is. Polo Boy says free my little bro. Mr. Thomas says it's better than 75%. Yeah, that's sad, man. It's sad that these snitches just flip on anybody and these people get convicted at a rate of 60 to 75% of the time. That's scary. We need to take back our country, man. Like, we really do. We need to totally revolutionize what's happening in our court system. Too many good dads are paying way too much in child support, not seeing their kids. That's a huge one. That is a huge one. I paid way too much child support in my life, but you know what? I was always there for my kids too. But that one hurts. And the criminal system, man, it's just a mess. You know, I've learned along the way that if you have a really good attorney that has really good relationships, like their fathers were former judges, those attorneys win a lot. And they don't win because they're good attorneys. They win because of relationships. And that's not the way that the legal system was supposed to be. The legal system was supposed to be, you know, a pure way of being able to prove your innocence, right? And it's not that way anymore. Now you're kind of at the fault or the mercy of the court and the relationships that you know are in the court with those persons, you know, that are your judge, jury, and executioner. And you know, having a jury trial is about as fair as it gets, and it's still not that fair. It really isn't, because a bad judge can strike down evidence and impeachment processes and everything else and completely sway the jury against you if they want to, just by not allowing certain evidence in, right? Or allowing certain evidence in that shouldn't be allowed in. But in this case, going back to Terrion Arnold, my biggest question is this. It says twice in there in that pretrial motion for Randazzo and Del Valle that their post-Miranda rights testimony matches the plea, right? All the information matches the plea. So that is exactly why that attorney on Thursday, which I do not believe is the same attorney that Terrion Arnold has now, he asked for the Brady material, right? He wants to know what these people said at the time of their arrest. Anytime that they talked to a police officer, they wanted that information. And he wanted that information because if that information doesn't match what these pleas say, and he wants the pleas as well, then I think that you have a problem with the prosecution. And he didn't get that information. And we don't know if anything transpired over the weekend. As that judge, I think Murphy is his name, said that if that attorney for Terrion Arnold wanted some additional information or was going to try to work with the chief judge in this case, and that chief judge was going to allow something, that, to work, with their offices, for the rest of the week and throughout the weekend. So I don't know if anything has transpired. I guess we'll find out tomorrow at 9:30, and it'll be hopefully right here live. We'll be going through it. All right, we got 17 votes. We got about 160 people in, man. Let's get these votes up. Will Terrion Arnold be convicted? Remember, all of your votes are confidential. Nobody knows if you voted yes or no or unknown. I think Trace voted unknown, though. She gave that one away. Maybe not. Maybe she was just looking out for everybody. She tends to do that. Oh, it means that the rat will leave a sinking ship. Oh, yeah. Mike P, have a good night. Give a hug to Mrs. P for us, man. Big heat wave coming in this week, which means the studio is going to be really hot. We've been busy packing all sorts of stuff, getting this house ready to go up for sale. And this air conditioner I have in here is not the one that I should have put in here, but it's already hot in here now. But I was saying all that to say, I hope y'all stay cool this week. It's about time we actually have some summer weather. It's been awfully weird here in Michigan. Cold, rainy, barely in the 60s. Got the PC fixed, if you can't tell. Got it fixed. Happy about that. Arnold is sinking. Uh-oh. Take a look at this guy again. Wait for your votes to get in. Let's take a look at some of this guy's cases. Kellen Winslow Jr., facing life without the possibility of parole, will be defended by top NFL lawyer. So I watched this video. If you go to this guy's, here, I'll pop this in the chat. If you go to this link and look up this guy's information and then follow through on some of these, click on them. If you click on that one of Kellen Winslow's bail denied over the judge's fear, he's like Tom Cruise. That was the most wildest shit I have ever heard come out of a judge's mouth. I'll give you the Cliff Notes version, which tells me that this guy's dealt with everything. He's seen it all. But Kellen Winslow was going through the same thing, pretrial detention hearing. This attorney, Mr. Steinberg, was there to defend him. And what the judge said, or I'm sorry, what Steinberg said was, well, there's no reason why he can't be at home. You can put him under monitoring. You can put an ankle bracelet on him. You can put cameras in his house. You know, if the state wants to put cameras, he'll pay for it all. Put all the cameras in all you want. You can watch them all day long. And the judge is like, well, then, how do I know he's not like Tom Cruise in Mission Impossible? And he's just going to put a loop on and, he's free now. He's gone. But yet there's the Russians, they put these loops on. And next thing you know, Tom Cruise has stolen everything and he's gone. I'm like, what? Like, is this seriously coming out of a judge's mouth right now? You're trying to say that this defendant is going to be like Tom Cruise and this is a movie? This is how far we have come in the court system? That we're now comparing a case to Mission Impossible? Wow. I thought I seen and heard it all. That's a new one for me. What else do we have in here? DA withdraws request to jail John Bolin, son of Broncos owner, because of an unsigned paperwork. Ooh, that sounds like... let's click that. Let's see if we can find out. When was this? So they must have found some sort of a loophole. This is back in 2017. So Bolin was accused of violating his probation during a drunken driving incident in California in July. But because this paperwork was unsigned, they're not going to prosecute, or they're not going to, take it forward. They're not going to jail the guy. As those eyes are glossy for sure. I mean, come on. That's some pretty wild stuff. I won't go into this one about the oil tycoon. DA dismisses sexual assault charge against Denver oil tycoon. Former Nuggets guard Ty Lawson denies probation violations in Denver court hearing. Ty Lawson gets 1 year of probation for a 2015 drunken driving case. Sentencing was continued for former Nuggets Ty Lawson, Harvey Steinberg, man Colorado sport figures call when in trouble. Aaron Hernandez arrest. Wow, was he Aaron Hernandez's lawyer? There's no links to these cases, but I want to look them up. I want to go through them. I mean, he's definitely got some big cases up in there. Anyway, I'm about out of here. I got to get ready for the morning. We'll try to pop in here in the morning and be ready on time, early. We'll be early tomorrow. Try to be early tomorrow. Be hanging out. All right, 43% of you feel like Terrion Arnold could be convicted. Only 28 votes. 29% say no. 29%, well, not sure. Unknown. So we'll see you guys back here in the morning. Terrion Arnold live for the pre-trial detention hearing. Hope it all goes well. And at any rate, like I've said, I'll stand, firm on my 2 feet here. Terrion Arnold is innocent until proven guilty. That doesn't mean that he's going to remain a lion even if he beats this case. It doesn't mean that he's going to be allowed to go to training camp if, in fact, he's allowed to not be detained while this case is moving forward. I know a lot of you, and I want to reiterate what I said from the very beginning. And I don't mean a lot of you in currently right now. A lot of you that may be watching this at some point. I've seen your comments on social media. I've refrained to comment on a lot of them. I hate social media anyway. But the thing that I kept seeing is I kept seeing people hate on TA because of the way he plays or the way he played his rookie season, and making comments like, we're better off now. We don't need TA. TA sucked. TA was garbage. TA was trash. Blah, 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 blah. And just completely trashing the guy about his play. And then linking that to this case, like those two things have anything to do with each other. People are people. You're going to do and say whatever you're going to do and say. But I don't think that's the one pride, man. I don't. I know a lot of the one pride, and I think you're all are great people. And I don't think that any of you would be making statements like that about anyone, on this team, no matter what the circumstances are. Their play has nothing to do with the human element that this guy is behind bars. He's facing life in prison. This is a serious situation for, the people that were involved, both the criminals and the victims, and for TA. This will never go away for him. And it will haunt him for the rest of his life. Even if he is found not guilty and he is allowed to play, this will haunt him every day on the football field because people will take advantage of it. They will use it to get in his head. And through times like this, the one pride usually stands up and tries to protect each other. So we need to be there through the good and through the bad. This isn't a good look for the fans either. Imagine what the other fan bases are saying. And look how they treat their players. Look how they treat their team. Why would they do that? When I've watched probably a dozen videos over the last couple of days from people that I've never seen before because they're covering the Terrion Arnold case because it's so huge. Just random creators. And they're not negative. They're not talking crap. They're stating the facts. They're going through it. being, completely, I guess, independent, as a fan. And they're not swayed by his play or, how he played in his rookie year, his second year, his injury or anything like that. They're stating the facts. They're going through the case. And a lot of them are saying it doesn't make sense. So support is coming from places where you wouldn't expect it. And it's not even coming from our own team. Matter of fact, like the one Twitter post, and you all know who put it out there, where they got TA looking down and saying, it's me looking at the CB1 and, now in front of me or something like that. And just totally mocking the dude. Like, those people have no business even covering the Lions. They really don't. They suck. All they are is clickbait. All they do is drive divide. It's toxic. And it's not who we are. And if we're going to let those types of people represent who we are, we got a problem. So don't be those people, man. I can't tell you how to act. It's not my place. Not my place to tell you how to fan. All I'm trying to say is I know we're better than that. And TA deserves better than that. If he's guilty, he's guilty. And he'll be treated as such. But if he's innocent, then we need to treat him as such. So that's it. We'll see you guys in the morning. Appreciate you guys joining us. Have a wonderful night. We'll take, what was that last comment? Oh, yeah. Good night to you, Major. We'll see you guys. Take care.
Pressured by Hutchinson. He goes down.